following program is classified G. It's suitable for all ages.
Tonight, we discuss the laws that govern marriages in Sri Lanka and how the dissolution process has been recognized. The critique of marriage laws has been that when it comes to divorce cases, certain aspects haven't been recognized in the eyes of the law. However, the objective of the law has been clearly to support the most favorable outcome for both parties. How has the law of marriage evolved over time? Where are the loopholes and how can they be addressed moving forward? Welcome to Law, Land and Liberty, where we're keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Now, this week's topic is something that affects a lot of families around the country, something that we need to break down and really understand, given the kind of stakeholders that are involved, especially with regards to the legal elements in reference to this specific topic, and that is with regards to the dissolution of marriage. Now, this is the most fundamental unit within society, that is family, that we'll be discussing today, and a very sensitive subject, that one would say. And to give us a breakdown, we have with us an experienced litigator, President's Counsel SK Lankathilleke. Thank you so much, sir, for joining us on today's program. As usual, what we do for our viewers is we give a breakdown of the program, the segments that we're going to discuss, so it's easy for the viewer to follow exactly what we are saying. We are going to start off with discussing the General Marriage Ordinance and give all of our viewers the fundamental law that allows for dissolution of marriage, or how marriages are recognized in the country. Secondly, we are going to talk a bit about alternate remedies and penalties in relevance to dissolution of marriage, and finally, key areas of reforms.
Hi, my name is Kimma. I work as an executive in shipping industry. My question is on the General Marriage Ordinance. What are the key provisions in the General Marriage Ordinance within our country?
All right, let's get into the topic directly. Sir, once again, thank you for joining us. The marriage ordinance, that I believe it has been amended at certain points, but there is a certain level of history that is involved with it. You have a wide amount of experiences with this rather sensitive matter. How would you exactly explain to our viewers who might not be too clear about the fundamental law behind this? How would you enter this entire topic?
Yes. If a party wants to obtain a divorce, you have to file an action in a competent court in Sri Lanka.
Yeah.
The competent court is defined in the Judicature Act, Section 24. Section 24 of the Judicature Act says the competent court is the district court of Sri Lanka.
Right.
So you have to file an action in a district court. And that is set out in the General Marriage Ordinance, Section 19(1) and 19(3). And again, there must be a valid ground upon which you can file a divorce action. Those grounds are also set out in the General Marriage Ordinance. Section 19(2) gives 3 grounds on which you can obtain a divorce. Therefore, I must say the substantive law pertaining to divorce is set out in the General Marriage Ordinance. The procedural aspect of law, procedure of taking, obtaining a divorce is in the Civil Procedure Code, Section 42.
Right.
So, as I said, Section 19(2) of the General Marriage Ordinance, they have introduced 3 grounds upon which you can obtain a divorce.
Yeah.
One is adultery, second one is the malicious desertion, third one is the incurable impotency at the time of the marriage.
Right. Right.
The adultery, it says adultery at the time of after the marriage.
Right.
So his or her past conduct is not being
Relevant.
taken into consideration,
Yeah.
not relevant. So jurisdiction is the court, district court, where either part resides.
Okay.
In a courthouse where husband resides or the wife resides, you can file the action.
Okay.
Unlike the other cases like money actions or the land action, where the defendant resides and or the cause of action arises. But here the divorce action is convenient. You can file your action in both courts.
Right.
Then if I talk about the adultery,
Yeah.
how you should file an adultery action and how do you proceed the adultery action on that basis,
Yeah.
on that ground, is explained in section 589 of the Civil Procedure Code.
Okay.
Section says, if your cause of action is adultery, then you must make the co-adulterer another defendant.
Okay.
Then you are going to have two defendants, your spouse against whom you have filed your action, and the other co-defendant who either misbehaved with your wife or
Yeah.
who did that act of adultery.
Right.
So if that particular section further goes on to say, if you do not want to proceed against the adulterer,
Yeah.
then of course you must get him excused from courts.
Okay.
If the co-defendant is leading a life of a prostitute, or if you don't know where the other adulterer is living,
Yeah.
or if the other co-adulterer is dead, then of course you must narrate all these facts in your plaint and along with the affidavit.
Right.
In your prayer you must say, you must plead that prayer to exonerate the adulterer and obtain permission for you to go ahead with the defendant with your other spouse, against your other spouse.
Right. So yeah, please continue on that same line. I think you're giving a very good breakdown of exactly how we need to understand this. What are the other criminal elements? Are there criminal elements that could be that will be considered in these regards? Is there allowance for that when considering the reasons for dissolution of marriage, or are they completely civil matters?
It's completely a civil matter.
Right.
You are entitled to damages from the co-adulterer.
Okay.
And also you are entitled to claim alimony from the wife or the husband who has done the matrimonial offense.
Yeah.
And you are also entitled, if the matrimony is proved, if the adultery is proved,
Right.
you are entitled to damages from the co-defendant.
Okay. You can continue on the exact same lines. If we, please.
Yeah. Then
The question that I wanted to just raise was the segment on void marriages. That's something that you were mentioning.
That's right.
Yeah, if you could
Yeah.
get to that as well.
Then the other important thing is now adultery has to be proved like in a criminal action. The degree of proof is very high, like in a criminal action.
Okay.
So therefore, when you plead, of course, when and where the offense occurred has to be pleaded in your plaint. Not only that, you have to establish that fact beyond reasonable doubt.
Okay.
So this is difficult,
Yeah.
very difficult,
Yeah.
especially when there is a co-defendant. Very difficult to serve summons, and it will take time. And in most cases, parties who file actions on those grounds abandon the cause of action against the co-defendant and proceed.
Right.
The malicious desertion is twofold: malicious desertion and the constructive malicious desertion. I must also stress the fact I forgot to tell you. Our law, according to our law, only the innocent party can obtain a divorce.
Okay.
Innocent party has to file the action and against the guilty party, and he or she can obtain the divorce on those grounds that I have stated if he or she is innocent. Therefore, our system is called forward-based system.
Right.
So, simple malicious desertion, the innocent party remains in the matrimonial home, guilty party leaves the matrimonial home with the intention of permanently repudiating the marriage contract. So, the factum and also the leaving the matrimonial home, intention, factum and the intention both has to be present.
Right.
In constructive malicious desertion, the innocent party leaves the matrimonial home because situation would have developed to a certain issue where he or she can't live in the matrimonial home any longer. There is no option, no alternative other than leaving the matrimonial home. She leaves, and she is the innocent party.
All right, I was just about to ask you, in that instance, what would be considered as the innocent party? Is there some definition for what an innocent party would be, or would that be up to the discussion of the judge to decide based on the facts?
Yes, that will be decided by the available evidence.
Right, okay.
Yeah.
Please continue.
Yeah, whenever sometimes we have, there are instances where parties file actions on the ground of constructive malicious decision.
Yeah.
Then the defendant files answer saying that no, she's guilty of malicious decision, and I have not committed any matrimonial misconduct, matrimonial offense. She maliciously deserted the matrimonial home, therefore she is guilty of the offense, and therefore the decree may be given in my favor, something like that.
Right. So in that instance, just to clarify, what is considered to be the offense in that scenario? If I'm not clear, if an offense is proven in that instance, damages will be the sort of like what will be awarded. We can go into penalties later on, but like what would be considered
the
the
actions filed on the basis of malicious decision or constructive malicious decision. The remedy is you get you can obtain the divorce, and at the end of the case, you are entitled to alimony,
right?
Not damages.
Right. If I were to say, as a final question before we go into a small break, sir, the offences would also be the grounds for a dissolution of marriage. Would that be considered the same, or no, that would be different? In certain instances, that would be the same, is it?
Yes. Offences, situations may arise when they are living together. I must tell you before that, this is a very difficult topic.
Yeah.
Unlike the other actions, because if you take a land action, for example, you have the deeds.
It's more black and white.
Black and white.
Yeah.
But here, test is who is at fault.
Yeah.
Court is trying to, by way of evidence, by listening to witnesses, court has to find who is at fault, because at the time of the marriage and when they were living happily in one matrimonial home, they don't think of a future divorce action. Therefore, absolutely there is no evidence. It is ultimately your evidence, verbal evidence, as against your opponent's evidence. So there had been instances where unreasonable treatments toward the other party, and continuous cruelty or assaults on the other party, and situation may develop to a stage where you mentally and physically you do not feel like staying in this house, and there is no alternative when you leave the matrimonial home.
Right.
That is the test.
Right. So I want to get a number of clarifications on what is considered to be a matrimonial home and what this separation is like and what defines a marriage within this context. We'll take a very short break and we'll come back and we'll extend this discussion with President's Counsel Sri Lanka to the state.
My name is Sayushmanta Vikramasinghe. I am a management undergraduate. My question is on alternate remedies in relevance to marriage. What are the key alternate remedies available in relevance to the dissolution of marriage in Sri Lankan law?
Alright, welcome back to Law, Land and Liberty. We are in conversation with President's Counsel SK Lankathilleke. A very important first segment that we've just passed, and so I think important identification you made was this is a difficult subject, a rather sensitive subject that we are discussing at this point in time. What are the next steps that we can take in terms of giving sort of clarity to the audience in terms of identification? Because now one issue I had was with regards to the innocent party, and I think you explained how that clarification is done. It comes to the discussion of the judge. the marital home, things like these elements that are involved in marriages, how are they identified? Does the fact that two people live together, that cohabitees, that result in a recognition of marriage? What, if you can give us some identifications of those things, I think that will be important.
Generally, a couple, parties after the marriage, find a place to go and live together.
Yeah.
They eat together, they cook together, they go shopping together, come back and live together in one house. That is the matrimonial home.
Yeah.
That is their matrimonial home. They live for some time and sometime, they may go to another house if they are in transferable services and all that. So that is going to be their next matrimonial home.
Yeah.
So if a party thinks that we should end the marriage, one party leaves the matrimonial home.
Yeah.
So sometimes decision can take place under the same roof also.
Okay.
Party, when situations develop to a stage where they can't share one bedroom together, there are instances where one party goes and lives in another room.
Yeah.
They eat separately, they cook separately, no matrimonial relationship at all. Still, the decision has taken place.
Right.
It's taken place. So those things have to be identified by evidence.
Okay.
But intention of repudiating the marriage must be there.
Okay.
The intention to permanently repudiate the marriage must be there.
Okay.
So that has to be identified by evidence.
Okay.
The constructive malicious decision is easier to identify because the innocent party leaves the matrimonial home and thereafter if there is no invitation from the other party to come back and resume cohabitation, then that is the thing that judge is going to fathom by listening to the witnesses.
Right. So one question that I want to ask you, because last week we discussed about the role of lawyers and the entirety of how that works. In this system, since we have an adversarial system of
Yes.
how our legal system works, what is the role of the judiciary? What is the role of the legal fraternity when involving themselves in cases of marriage? Is the fundamental thing that they will be involved in is to look after the general rights of whoever they are representing, or in the judge's case, to give the most fair decision? What are there conventions that describe, okay, this is what you need to look into? Is there a direction to say, okay, we need to look at the best interests of the marriage, maybe the best interests of the two parties individually, the children? What are the priorities of the judge?
Actually, the public interest is to safeguard marriages.
Okay.
When there are children, when parties come for consultations, of course, we discuss and we, at a consultation, we try and see whether there is a settlement or a compromise possible.
Yeah.
And if they persist that there is no settlement in this case, somehow they must file an action. I can't live with this man, and we must file a divorce action and give me a decree dissolving this marriage.
Right.
Then of course you listen to the facts, and then you have to organize your facts in line with the marriage grounds.
Okay.
So fit into the grounds, and then you draft your pleadings and ask a divorce. In fact, actually, we generally practitioners, of course, don't persuade parties to file divorce actions when there are children, and they have lengthy consultations, and thereafter, if they really want to go for a divorce, they file the action.
Okay.
And carefully do the pleadings. And as far as the judiciary judges are also concerned, they, at the first instance of they try to refer the matter to family councils. And the moment we say that there is settlement possible, judges postpone the case, and they give the maximum support in order to reconcile the parties if they really want to.
Right.
But if the case drags on, then of course they take the matter But before that, they really try their best to settle the matter.
So something I want to clarify in that line itself is something that you mentioned within our first segment on the issue of impotency, which and how it affects the issue of dissolution. If you can give us an elaboration there.
Yeah, the third ground on which that you can get a dissolution for, that can get your marriage dissolved is according to section 19(1) of the Marriage General Ordinance, is the incurable impotency at the time of the marriage.
Right.
So the impotency after the marriage is not taken into consideration. So this is a very, very easy to establish, but very rarely you find these type of cases are being filed in our courts.
Right.
But it's also a ground in the set out in the General Marriage Ordinance and easy to establish with medical certificates and all that.
Right. So in continuation there, if you could mention to us, are there any steps, also are there any common law elements that come into play about developments made in terms of either of those grounds, any one of those grounds or the extents of those grounds? Because when it comes to an issue such as impotency, whether the parties were aware is a question that may arise, but you said that the medical evidence would suffice. Are there any other areas that common law has gone into, or under the prevailing conditions, under the prevailing law, these are the only sort of steps that can, only sort of avenues that are available for in order to dissolve the marriage?
In addition to these three grounds set out in the General Marriage Ordinance, there is another ground introduced to the Civil Procedure Code, right, that is section 608, where parties can file papers to obtain a decree of separation.
Okay.
You have to file a plaint like a normal action to obtain a declaration for a legal separation.
Right.
And according to that section, after the decree of separation, after 2 years, under summary procedure, you have to make an application to get the divorce.
Okay.
And in the same section, if two parties are living in separation, they call it mensa et thoro, from bed and table.
Right.
You can file an action for divorce,
Okay.
but summary procedure. This remedy is also available to innocent parties. Just because you lived in separation for 7 years, you are not entitled to obtain that relief.
Right.
There is a
This is in terms of relief, sir, because my next question was going to be on the voidable
Yes.
marriages. How exactly is this there more that you wanted to?
Yeah, that remedy, all what I have to say is, although you live in separation for 7 years,
Yeah.
court has to find who is the guilty party.
Okay.
So the remedy is available to the innocent party.
Okay.
Now, of course, I think Justice Ministry has appointed a committee to go into these things. They are going to introduce, after obtaining a decree of separation,
Yeah.
rather than filing papers again under summary procedure,
Yes.
you can just make an application to obtain a divorce. So make things easier for those who are living in separation.
Yeah.
And really, if there is no hope of reconciliation, to obtain a divorce.
Yeah. So let's just move into a bit of these remedies and the penalties that are available in resolution to in relevance to the dissolution of marriage cases. Now, there are issues of annulment, where marriages are unrecognized due to certain issues that may arise, alimony that is going to be paid, and interim relief that is awarded to these parties. How exactly are those justified? What are the procedures that are involved in awarding these? Should it be involved? Should it be mentioned in the prayer, and based on that the judge makes a call, or how does that come to life?
First, I'll deal with the the other category of marriages like void marriages and voidable marriages. Void marriages are void ab initio, void from the beginning.
Okay.
Therefore, filing an action to obtain a declaration that the marriage is void is not necessary. Supreme Court has decided in number of cases that the action is not necessary.
Okay.
Even if you file an action, a court does not have power to convert a void divorce to a legal marriage.
Okay.
Like void marriage to legal marriage.
Right.
What the definition is.
Yeah. What is the identification of void marriage in that? Yeah.
Void marriages, of course, Section 15, Section 7, Section 15, Section 16, Section 18.
Okay.
If the parties are under the age of 18,
okay,
marriage is void from the beginning.
Okay.
Therefore, no action is necessary. The Section 17, Section 15 of the Marriage General Ordinance, the section starts saying marriage shall not valid if the parties are under the age of 18.
Right.
That is the sentence.
Right.
Therefore, no action is necessary. So, according to law, the void marriages do not exist.
Right.
Voidable marriages exist until courts declare that the marriage is void.
Okay. If you can provide some examples on that.
Yeah. So, if you are previously married,
Right.
and while the marriage is subsisting, if you register another marriage, second marriage is void ab initio. So, the action is not necessary.
Right. So it's void. It's a void marriage. Yeah.
The section, I think 17 says the prohibited degree of marriage, if you get married to a daughter, your own sisters, son, brothers, they are void from the beginning.
Okay.
And you mentioned about the penalties.
Yeah.
If you register a marriage hiding the fact that you are previously married, of course you are doing a criminal offence.
Right. Right.
So there are remedies, penalties under the criminal procedure, penal code, as well as under the marriage registration ordinance under section 18.
Yeah.
Yes, you can take an action, and the punishment will be definitely less than 1 year. But the penal code is, I think, much more severe.
Okay. Okay.
So the file papers under beginning, and the marriage is void, and at the same time you are doing a criminal act.
Okay.
Then
something I want to just add on to that, sir. If you can visit the points of alimony and
yes.
Things like interim relief, because those are not concepts that people are too clear about, and are even less clear when it comes to the Sri Lankan context of these things. If you can shed some light as you go ahead with explaining about voidable marriages.
Yes. So when you file an action, you file an action on a matrimonial fault on the other party.
Yeah.
And you are asking a divorce.
Yeah.
And at the same time you are pleading for alimony. And if court finds that you are the innocent party, then court under section 615 of the Civil Procedure Code grant alimony.
Right.
Alimony, a lump sum or a monthly payment. By your monthly payment you are entitled, and court has the jurisdiction to grant.
Right.
Or to write a immovable property in your name.
Okay.
Very many remedies are available.
That is based on whoever is the provider within that family, is it?
Yes.
Yeah, okay.
Yes. Depending on who is at fault.
Who is at
and
fault, right.
Court, of course, you must establish the fact that the defendant is in a financial capacity to pay.
Okay.
And court will look into the fact that how did they live their social life. If they maintain a high social life, then of course definitely and the payment entitlement will also go up. Then while the action is pending, you can file papers for alimony pending liability under section 614.
Okay.
that action has to be filed under summary procedure. It's an interim relief, in fact. You file papers and you can ex parte obtain decree nisi. Decree, the papers has to be served on the other party. They can file objections. If they don't file objections, nisi order will be made absolute.
Right.
But the quantum will depend on the income of the defendant, husband or wife. It is according to the section you are entitled, court will grant 1/5 of the income of the defendant.
That is what's mentioned in the law, is it?
That is mentioned in the law.
All right.
If they file objections, objections are being filed as to why the nisi should not be made absolute.
Okay.
That's the matter that court is going to try. So there will be an inquiry. At the end of the inquiry, if court feels that the application is genuine and the other party can afford to pay this much of money, and they'll grant a reasonable amount of money.
Right.
Section 614(2), even the husband can file alimony penalty application in order to obtain alimony pending the action.
Okay.
So that remedy is available to both parties, husband and wife. In the same section, there is a proviso, you can file papers for cost. The person who can afford to pay, and if the other party establishes the fact that he is unable to find money to go ahead with the divorce action, the person who is able has to pay cost. That application is a general application. Okay. It doesn't say it's a summary procedure.
Right. Okay, I think that makes sense. Before we go into a break on this segment, something I want to ask you. The law, I think this is more from your experiences as a practitioner. The law would specify these are the grounds for a dissolution of marriage or a legitimate dissolution of marriage. Are there duties recognized within the law for either party that is part of a marriage? These are the certain duties that should be maintained or conducted by these individuals. If not, the court will make that also a consideration when dissolving the said marriage, or is that something completely up to the situation, the consequences of that marriage?
General marriage ordinance doesn't come out with these duties.
Right.
But there are socially accepted duties towards the wife by the husband, towards the husband by the wife. Most of the divorce plaints, if you go through plaints, they plead that this duty, she didn't fulfill, the husband did not fulfill the expected duties during my matrimonial life. Husband has to provide a matrimonial home to the wife. And then wife must perform the matrimonial duties to the husband.
Right.
They are not divine, but socially accepted duties are there.
Right. All right, sir. I think we've covered quite a few important segments within the discussion, particularly pertaining to the fundamentals with regards to marriage and the fundamentals with regards to general marriage ordinance. Time has once again come against us and I hope we can meet again during another discussion. So if you can just come and shed some light with your vast experience on this matter. President's Counsel SK Lankathilleke, thank you so much, sir, once again for joining us.
Thank you.
All right. As we discuss this rather sensitive topic, it is important to bear in mind the core reasons why building on good marriage laws is needed and the stakeholders involved, such as the children. Author Louis D. Berniers once said, "An adversarial family law system raises the stakes unnecessarily high, exacerbates the antagonism of the couples concerned, and is directly responsible for making it impossible for couples who would otherwise have reconciled to do so." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can re-watch our entire episode on our YouTube channel, youtube.com/otherthanenglish. Join us again next week as we break down a contemporary legal topic. I'm Daniel Tanwasa. Have a great time.